Welcome once again to Lehto's Law. Here's Steve Lehto.
Every now and again, we talk about injunctions and what causes injunctions to get granted by courts. And James and James, two unrelated people with the same first name, sent me this story. Said, Steve, check this out. U.S. Appeals Court halts enforcement of anti-money laundering law. Nate Raymond wrote this for Reuters. And there's a law that recently got passed, and some people have objected to the law. And courts have now been ruling several different ways on whether they should block the law or not. Temporarily, maybe, who knows? So a U.S. appeals court has halted enforcement of an anti-money laundering law that requires corporate entities to disclose the identities of their real beneficial owners to the U.S. Treasury Department ahead of a deadline for most companies to do so. That deadline is fast approaching. And as you may have heard, some people out there who run businesses don't want people to know that they're running a particular business. So what is happening is you can, create a corporation or an LLC. It depends what state you're in, and you can set these things up, and you can kind of in the paperwork hide who exactly is benefiting from this business entity. And you may have heard, for instance, it's not uncommon for someone to create a business entity, then create another business entity, and the second entity controls the first. And then what you do is you create a third business entity that controls both of those. And you've pretty soon got all these different web of businesses that interact with each other. And someone trying to track this down has a heck of a time trying to figure out who's behind all this. And I'll give you the greatest example of all time is Enron. Look up Enron's corporate structure, and you'll realize that it was something that it probably wasn't even understood by the people at Enron, who I hear were some of the smartest people in the room. There's some great documentaries about Enron out there. So the New Orleans-based 5th U.S. Circuit Court of Appeals reinstated late Thursday a nationwide injunction that had been issued by a federal judge in Texas who had concluded the Corporate Transparency Act was unconstitutional. So the law is called the Corporate Transparency Act. The order from this court marked a change of course for the court. On Monday, a 3-judge panel of the 5th Circuit, at the urging of the U.S. Department of Justice, put the injunction on hold while the government appealed the Texas judge's decision. So Texas judge said unconstitutional. 5th Circuit at first said, well, we'll put that on hold. And then they said now they've reinstated it. A different panel will ultimately decide whether to uphold the judge's ruling at the lower court. And in Thursday's order, the court said it decided to keep enforcement of the law paused to preserve the constitutional status quo. That's extremely important to understand here. We're not just talking about the great ban from England, but the status quo in a legal context here. While the merits panel considers the parties' weighty substantive arguments, those arguments will be heard in March. Most companies had faced a January 13th deadline to submit their initial reports to the Treasury Department's FinCEN, the Financial Crimes Enforcement Network. But in light of Thursday's order, FinCEN on Friday said companies are not required to file beneficial ownership information with the agency just yet. And I've never liked the phrase crime enforcement. Shouldn't it be law enforcement? Oh well. However, reporting companies may continue to voluntarily submit beneficial ownership information reports. The injunction had been obtained by a lobbying group which, along with several small businesses, challenged the law through lawyers at the Conservative Center for Individual Rights. Given that we've established that the CTA is likely unconstitutional, this intrusive form of government surveillance should be halted until the law's fate is finally resolved, said the Center for Individual Rights president in a statement. Under the law, which was enacted in 2021, corporations and LLCs were required to report information concerning their beneficial owners to FinCEN, which would then collect and analyze the information about financial transactions in an attempt to combat money laundering and other crimes involving money. The measure's supporters said it was designed to address the country's growing popularity as a venue for criminals to launder funds by setting up entities like limited liability companies under state laws without disclosing their involvement in those businesses. U.S. District Judge in Texas in December ruled that Congress had no authority under its powers to regulate commerce, taxes, and foreign affairs to adopt the quasi-Orwellian statute, that it likely violated states' rights under the U.S. Constitution's 10th Amendment. So keep in mind that most corporations you hear about are chartered by a particular state, quite often Delaware, but there are a few other states quite popular for incorporation. But those are state laws that say if you want to incorporate, here's what you do and here's how you do it. And so there are states that are granting the corporations and the LLCs, limited liability companies. And so this judge is saying that the feds are trying to regulate this, but this appears to be a state question. Now, of course, money does move in interstate commerce. Interstate commerce is something that Congress has authority over. The question is, how much authority do they have? So the law was on the books. It was about to go into effect. Federal lawsuit filed in Texas, and a judge said that looks like an overreach, in my opinion. I'm going to block its implementation. Then they ran up the Court of Appeals. Court of Appeals said, we're going to lift that stay for a second while we think about this. And then they said, we're going to reinstate it until we can have a full hearing on this. And that actually makes the most sense, regardless of which side of this you're on. And to get an injunction, we're talking about a preliminary injunction. And an injunction is where a court orders someone to either not do something or to do something. Where they're ordering somebody to do something. It's not the payment of money. That's just money damages. Money damages solve a lot of problems, but once in a while you need an injunction, okay? So let me give you an example. Let's suppose that two parties are fighting over who owns a building. One party says, we own the building. The other party says, no, we own the building. The second party says, by the way, not only do we own the building, we're knocking it down tomorrow. First party says, yeah, but we own the building. Second party says, we don't care what you think. It's not your building. So the first party could go to court and sue and ask the court to rule that they own the building. But if it gets knocked down tomorrow, what good does that do? I mean, you're going to get a piece of dirt with no building on it. So that would be a situation where an injunction would make the most sense. You run into court and say, hey, look, we got a problem here. They're about to knock down a building that we say is ours. We think we can prove it's ours. But if we don't get a ruling immediately, then this all becomes moot. And so what we want the court to do is issue a preliminary injunction to stop the building from getting knocked down while we resolve this. Because if we win, which we think we're going to win, that building needs to be there. And if the other side comes into court and goes, just, Your Honor, no, we own the building, the judge is likely going to say, would it hurt you to just leave the building up for just a little while longer while we resolve this? And that is something we can refer to as the status quo, leaving something as it is. And so quite often courts will lean towards leaving things the status quo, because if you don't and things change and then the court later orders them to be changed back, it gets messier. So what do you do if you don't issue the injunction and the building gets leveled and the court rules and says, yep, building belonged to them? Well, now you got to calculate damages and do a bunch of other stuff. And what if the building was unique? What if it was like an old building that had some, value to it in that manner? And so there are some situations where you often hear about injunctions being issued preliminarily. And one of them is where something's about to get knocked down or destroyed, which could not be rebuilt easily. That's one of the most obvious ones that comes to mind. But when the court is looking at whether to grant a preliminary injunction, okay, the court will look at several factors. And this is true in courts all across America, but I'm only licensed in Michigan. But one party comes into court and says, we want a preliminary injunction right now. The court is supposed to look at what the likelihood is that this party is going to win. So they can't come into court and just ask for it. They can't go, we say the building's ours. You better come into court and put down a bunch of information that the judge can look at right now to say, okay, you've got a strong case. That can be affidavits, or you could even demand a hearing and have someone testify. Keep in mind, a court might say, we haven't got time for a hearing. They're knocking the building down at 8 a.m. tomorrow morning. It's already 5:30. I need to be home. I got to watch American Idol. No. So you got to come in and convince the court that you've got a high likelihood of success on the merits. Then the court's supposed to weigh that against what would be the harm if it's not granted, and then what would be the harm if it was granted. So in a case of a building that's standing right now, and let's assume it's not leaning over and threatening to kill people nearby. There's a building that's been standing there for 150 years. Will it hurt anything to let it stand for 1 week longer? Because what will happen when they grant the injunction is they'll grant the injunction and then say, okay, now let's figure out what's going to happen long term. And I've gotten preliminary injunctions before in cases where something was about to happen, we got it stopped, and then we had a hearing a week later about whether or not the injunction should stand. And in a case like this law was about to go into effect in January, where people would have to do the reporting, the actual action part of the law. And the court is now saying, well, we're going to let people not report because if the law winds up not being legal, you didn't need to report. And if they did need to report because the law turns out is legal, well, will it really hurt anybody that much if they report that in June as opposed to January? Really? So when they start weighing the equities, as they say, so the court will look at the balancing of the hardships between the parties if you grant it versus you don't grant it. And here, granting the injunction doesn't really hurt anybody all that much. But if you didn't grant the injunction and later on ruled it unconstitutional, well, that would have been a waste of time and effort by a lot of people. So it makes sense to grant the injunction and then hold a full-blown hearing on the enforceability of the law. But keep in mind that the status quo is often one of the things the court will look at because the way things are right now, will it really hurt to leave them that way for a few more days? Really? And more often than not, the answer is no, it won't. It won't hurt to leave it that way for a few more days. However, letting something happen, changing the status quo, and then saying, let's move it back and make it like it was before, that's where things get difficult. So the court's saying, until we resolve this, they're going to leave the stay in place. And the stay that is in place is the injunction saying this law is currently unenforceable until we get a chance to rule on its merits. So James, thanks for sending that. U.S. Appeals Court halts enforcement of anti-money laundering law. Nate Raymond wrote that for Reuters. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. You can't have everything. Where would you put it?